Lovely to have you with us this afternoon. This is the Newsfeed PM edition. Now, the effectiveness of traditional medicines against COVID-19 has once again come under the spotlight after Madagascar highlighted the potential benefits of COVID organics, which is a tonic derived from Artemisia. Artemisia is popularly known in South Africa as umhlonyane or in Zulu or in Sotho lingana. Recently, the Department of Science and Innovation announced plans to research traditional medicine in the fight against COVID-19. But how can traditional knowledge be protected as intellectual property? Well, for more on this, we are joined this afternoon by Pieter Visagie. Pieter is partner and patent attorney at Adams & Adams. Thank you for your time this afternoon, Pieter. Perhaps let me start with an appreciation of traditional knowledge systems as intellectual property. Do we, as South Africa, as a country, actually appreciate what it means to have traditional medicine as intellectual property, as well as what that intellectual property can do for the country?
I think we have certainly tried to create proper context for it. When we're talking about traditional knowledge, of course, we're talking about knowledge that's been in existence for quite some time and has been developed within an indigenous community and has passed from generation to generation within that community. So it's not recent knowledge that we're talking about that's been developed within the past few years or within the past few decades. And in that context, the existing intellectual property systems, unfortunately, are significantly deficient in recognizing traditional knowledge that has been in existence for quite some time in a form in which it can be protected. And some strides has been made by government in order to provide some context for this. There are 2 acts that have been signed by the president. Unfortunately, they're not yet in force. And these acts are dedicated to the protection of traditional knowledge, essentially as a separate form of intellectual property. But in the context of the existing framework of intellectual property law, there's unfortunately only the Patents Act that recognizes indigenous knowledge, and it does so through the provisions of the Biodiversity Act, and only with reference to indigenous biological resources. So there is a void in intellectual property law when you're looking at protecting traditional knowledge as a body of knowledge that was in existence for centuries, if one might call it that.
And as you're talking there, you know, it sounds like there actually isn't any sort of protection for indigenous knowledge. And I'm thinking of the case regarding the Hoodia and the khoisan, that particular plant, that herb that grows in the desert that was used to accelerate weight loss, etc., and how that particular traditional medicine has actually been used throughout the world for weight loss, medication. Is that actually protected under South African law?
Well, one would hope that the relevant community did, insofar as the use was based on their traditional knowledge, that they did share in the benefits of the exploitation of that plant on a commercial scale. And it's specifically that which the Patents Act provides room for. And in fact, the provisions relate to applications beyond the Patents Act, in the sense that if anyone wants to engage in bioprospecting and commercialization of an indigenous biological resource, of which the Hoodia plant is definitely one, they need to obtain a permit from the Department of Biodiversity in order to get permission to exploit that particular plant. And a part of the requirements to be granted a permit is that a benefit sharing agreement must be concluded with any interested indigenous communities. So if the use of that plant was based on knowledge that was shared by the particular community, then certainly one would hope that at least some form of benefit sharing agreement was concluded, and that community would currently and hopefully continuously share in the benefits that accrue from the exploitation. When we talk about it from an ownership perspective, that is where the intellectual property laws have a void, as I mentioned earlier, is that the ability of an indigenous community to assert actual ownership and exclusivity over their knowledge, that is a very difficult question, because there simply currently is not a frame, or at least there's not in-force legal provisions that allow them to assert that kind of exclusivity. So one would hope that at least they are sharing in the benefits in terms of the provisions of the Biodiversity Act, But beyond that, unfortunately, we do have a bit of a difficulty in trying to provide these communities with, or put them in a position where they can assert exclusivity over their knowledge.
Correct me if I'm wrong, but my understanding is that pharmaceuticals, or so-called conventional medicine, they enjoy this type of ownership and this type of protection, right?
They do. They can enjoy it under the provisions of the Patents Act. But the Patents Act does not exclude traditional medicines or traditional remedies from protection. If you comply with the registrability requirements under the Patents Act, regardless of the origin or the nature of the particular treatment or medicine, you can obtain patent protection. But that requires, in one respect, that the particular treatment must be novel, meaning that it must not yet have been disclosed to the public. And regrettably, in the case of traditional knowledge and traditional medicines and therapies, seeing as those have been in use for many years, they are unlikely to qualify for patent protection because of that lack of novelty. And it, again, as I mentioned earlier, this is where the difficulty arises, in that we don't have a legal framework, or at least legal provisions, that classify traditional knowledge in a separate classification, place it in a separate box that actually allows that knowledge to be registered and protected under a different set of rules that are in force for so-called conventional medicines. And unfortunately, that's simply a way the law is developed. When these current intellectual property laws came into force, typically around the 70s and so on, there was not a recognition for traditional medicines, and no provision was made for their protection. And this is a difficulty that's been faced across the world. Many indigenous communities face a difficulty or a challenge of exploitation of certain parts of their knowledge. And in this regard, we even refer to designs, stories, artworks, and so on, without the necessary benefits accruing to them, simply because of a lack of specific IP provisions that would entitle them to some form of protection and exclusivity.
Is there a move towards putting in place the necessary laws to ensure that there is protection of indigenous knowledge?
Yes, there is. We have two acts, as I mentioned earlier. The one is an Intellectual Property Laws Amendment Act that came into force fairly recently. It was enacted in 2013, but it's not in effect yet. It needs to be proclaimed by the President to enter into effect by way of a proclamation in the Government Gazette. And what's holding it back at the moment is the formulation of regulations that would facilitate the application of the Act. The other Act that more directly relates to the protection of traditional knowledge as a form of knowledge, and one can even say as a new form of intellectual property protection, is the Protection, Promotion, Development and Management of Indigenous Knowledge Act. Now, that act was signed by the President as recently as August 2019, and it does go far in classifying indigenous knowledge as a new form of knowledge that is entitled to protection as a body of knowledge, subject to certain requirements. But unfortunately, that act also is not yet in effect. We're also waiting for a proclamation for the act to take effect and for the issuance of some regulations that would allow us to understand the practical application of it. But the Act does establish a separate office for the management and the promotion and the development of indigenous knowledge, which I think provides one of the clearest steps yet in order to recognize traditional knowledge and go a long way in protecting it to the benefit of the communities where the knowledge originates from.
When this eventually does get passed and it actually becomes law, who would be the official owners of this intellectual property? Would it belong to the country as South Africa? Would it belong to a particular tribe? How does one delineate and prove ownership?
I think that's one of the challenges that you rightly referred to is the proof of ownership and the determination of ownership, because intellectual property rights in whichever form ultimately need to vest in someone or in a company, an entity, a legal entity, whether it be a person or a company. And in relation to traditional knowledge, defining that community or that individual has always been a challenge, because there's a lot of cross-pollination, if one can call it that, of traditional knowledge between various communities. And the Act currently does not provide clarity in identifying the actual owner of the information, but it does provide that, or of the traditional knowledge, but it does provide that ultimate ownership, once it has been registered under the Act, would reside in a trustee. So the information would essentially be placed in trust, which would hopefully be then to the benefit of the originators of that particular traditional knowledge. And I believe that would ultimately be an historic investigation that would need to be undertaken to determine where the knowledge actually originated from, which might be challenging. But as I say, unfortunately, the Act doesn't guide us yet as to which forms of proof would be required in order to indicate or to prove that you are in fact the originator of this particular body of knowledge.
Let's take the situation that we've just discussed now and bring it closer to home. Just recently, the Minister of Higher Education, Science and Technology mentioned that a certain amount of resource would be put towards finding traditional cures for COVID-19. In the event that such a cure, traditional medicine, is indeed discovered, who would that belong to?
That would need to belong, and I hope it would ultimately belong to the community who indicated that a particular remedy may be useful for a particular ailment. Seeing as COVID-19 is such a recent virus that we are confronted with, it will be difficult to argue that a treatment has been used for this particular virus over the years. So one would typically look at traditional knowledge perhaps and see in relation or in the body of traditional knowledge which types of treatments have been used for similar conditions, and then perhaps look at those particular treatments to determine whether or not they might be effective. But the question ultimately remains, is the particular application based on or derived from traditional knowledge? And in relation to COVID, as I mentioned earlier, I think the direct link between traditional knowledge and COVID as such might be difficult to prove, although there may be some similarities between various conditions that may be treated. But the ownership question does remain a challenge to me. I think one would hope that a community who provides some sort of insight to whoever conducts research in making a suggestion to them of a potential utility of a particular resource, that they would be recognized as the owners of that particular resource. But again, unfortunately, under the current acts, they cannot register that information, and they would have to rely on the provisions of the Biodiversity Act in order to share in the benefits of the exploitation of that particular knowledge.
Oh, and I guess you've pretty much summed up my last question. I was going to ask you, we've been talking ownership, but if in one sentence you could sum up the importance of ownership. Let me give you that opportunity, Pieter.
Ownership is equal to control. Even things as simple as tangible property, if you have ownership over something, you can control it. If you can control something, you can assert exclusivity over it. If you can assert exclusivity over it, you can control other people's actions in relation to it, and that by implication leads you to the ability to derive benefit from it. And that's ultimately what you are after when you have information that is of value in your control, is you want to accrue some sort of benefit from it. So ownership is essential for the accrual of benefit to the appropriate location or to the appropriate person.
Thank you so much. A great conversation there with Pieter Visagie. He is partner and patent attorney at Adams & Adams. Do stay with us. We'll be back in a moment.